Samira?
Good to go, David Frederickson. You're ready.
Okay.
Are we all set?
Yes.
Outstanding. Hi, everybody. My name is David Frederickson. I am a coach with Petra Coach based here in Nashville and a 13 or 14-year member of EO. I can't losing count. Anyway, today we're continuing our exchange series on ways to protect the future of your business and your family. As we all know, we lost a very, very solid, wonderful person, member of EO, and it kind of shook a lot of us to attention. And there are lots of things that we need to get in order, that we should get in order prior to an event such as that happening to any one of us or the people we love. And for that purpose, we have asked, and he is gracious, and Rick Nichols has graciously joined us. Rick is a partner with Bradley here in Nashville, and I'm going to read his bio real quick just to let you know how perfect he is for this conversation. Rick Nichols is a member of the firm's tax and trust and estates practice group, practicing at the intersection of estate planning, tax, and business. His extensive experience helping clients tailor their wealth transfer and asset preservation goals in a tax-efficient manner. Rick regularly advises on federal gift, estate, and generation skipping transfer taxes, as well as federal income taxes. He prepares wills, revocable and irrevocable trusts, and other estate planning documents. I could go on, but the fact that Rick's background is both in business and in estate planning and helping businesses figure out what's next is a tremendous asset to us to have him here. So I'm really pleased to have Rick join us. Before I turn it over to Rick, what I'd like to do is kind of share with you the approach here. We first ran down the path when we were discussing how to go about this presentation as in the event of something happens to you, what should happen to your business? What do you want to do there? That mentally can be a challenge to get your head around. And so what we decided, another approach is to make this more conversational. Please raise your hand, jump in, put your questions into the chat as they come up. But what was helpful for me is to think about this topic in terms of what do we want to get from our, say, aging parents. If our parents are aging and we want to be able to plan for them, what is it that we need to do for them? And actually, it's the same thing that you would need to do for yourself and your company. So with that, I'm going to turn this over to Rick just to start talking about documenting your what you want to have happen after you go. Again, any questions, just drop them into the chat, and we'll take it from there. Rick, please.
David, yeah, thank you so much, and thank you for reading my bio. I haven't heard that in a while, and we have some really wonderful marketing people at Bradley who put that together. So thanks. I really appreciate the opportunity to be here with you all today to talk about this important and unfortunately for y'all timely topic about legacy planning. And there are some really fine legacy kind of binders material that frankly the financial advisors do a much better job of preparing than estate planning lawyers that really help y'all focus on things that you should be thinking about and doing both prior to death and post-death. And we're going to, on the back end of this program, share at least one of those with the group. But for now, for our time together, I want to focus on just three topics: document storage, asset alignment, and post-death steps. And within those three topics, we'll break at least two of them down into a couple of subtopics. So for document storage, kind of the what, where, and who, what documents to store, where to store them, and who to tell about them. Asset alignment, no subcategory there. And then for post-death steps, and we'll touch at a high level on the probate process and tax considerations. And so document storage, asset alignment, post-death steps. Those are the three topics, and which all kind of blend together for purposes of this series. All right, so let me just piggyback really quickly on what David said. I think the best use of our time is to have a conversation, if that works. And I'm happy to deviate from any of the material that I planned if it makes sense and is helpful to the group to have a conversation about any part of this. So please don't hesitate to raise your hand, ask David to chime in, put something in the chat room. Happy to do that. But short of that, why don't we just get started with the document storage? So this is your second session in this legacy planning series. The first one was, okay, what documents make sense to have? And so for purposes of our discussion, presumably you came away with, what I consider a suite of estate planning documents. And they can obviously vary from individual to individual, but that suite typically looks like a new will, perhaps a revocable trust, but a will, a durable general power of attorney, and a healthcare power of attorney. So those are kind of the typical estate planning suite of documents. All right, so then the question becomes, all right, where do we store those? And within kind of that document storage, again, it's what documents. So we have that suite of documents. And within that, your will, typically, almost every will certainly every will that I draft and almost every will that I see, makes reference to what's called a letter of instruction or a memorandum that addresses personal property. So heirlooms, jewelry, things like that. So it contemplates that there's a separate letter that your parents or y'all would prepare and have that accompany your wills. So within that suite of documents, I would include that letter of instruction, which is really helpful for your family members when you pass away. Because it really gives you the opportunity to think about, okay, do I want certain heirlooms, things of great sentimental value, to go to certain people? And that letter is the means by which you accomplish that. So in terms of what documents include that for sure. Another ancillary document, if you will, to the suite of estate planning documents is often what's called a trustee instruction letter. The trustee instruction letter is, oh, thank you. And so we're on the second slide, but for whatever, oh, I'm sorry. Yep, doc storage. I'm sorry, you were right. Thank you. So what documents? So the trustee instruction letter is a way by which to give your trustee, if there are any trusts created under your will, some guidance that really doesn't lend itself well to having it in the trust agreement itself. Okay, suite of documents, your will, healthcare power of attorney, durable general power of attorney, letter of instruction, and if you're so inclined, a trustee instruction letter. So those are the first kind of core documents. Beyond that, what's important to keep? So bear with me, if you will, and indulge me just a little bit on this analogy, but I think it will work with this group, and I think it will be helpful to kind of put our arms around what other documents should be stored. Think of that suite of estate planning documents as definitive sales documents. Think of it almost as a business transaction. Those are the definitive documents by which your aging parents or yourself are transferring your assets to your family members. And so if those are the sales documents, well, what would a buyer want to accompany those sales documents? The buyer here being your family members, your beneficiaries. What are they going to want to see? So what they're going to want to see would be what I would consider kind of to be the exhibits and the attachments to sales documents. So let's start with what assets are being transferred. So personal financial statement. I think that's critical to have included in the documents. I would update that annually. It doesn't have to be updated more than that, but I'd update that annually. I'd include a personal financial statement. And then think through, what does that personal financial statement do? It lists in detail, or at least it should, your assets and liabilities and where they are held. So that's a wonderful springboard into uncovering your assets and your other your liabilities. So what should accompany that? What should be scheduled there? Well, passwords. It's absolutely critical. So if your financial statement lists an account at Morgan Stanley, where's the password to that Morgan Stanley account? Where can you find it? You don't necessarily have to have a list of passwords as part of kind of these documents, but you have to have where to find the passwords. And that may be the most critical piece. And of those passwords, think also in terms of, okay, maybe to further this poor analogy, what are material contracts that you would want to include? Life insurance, okay? What life insurance do you have? Other insurance, where can you find those policies? Who's your agent? All of that information should be aggregated with your suite of estate planning documents. What about, I think the next session that you all are having deals with buy-sell agreements for your business. Okay, so if you're operating as an LLC, if you don't, and you have a co-owner, if you don't already have one, you certainly need an operating agreement with buy-sell provisions. So including that, or at least where to find that operating agreement, so your loved ones can see, okay, what does the contract say about their interest in this company when they pass away? So it's, if you think of it in that context, and again, the answer as to exactly what documents should be kind of aggregated will differ for everybody, but it really is the core estate planning documents. It's your personal financial statement, and then it's passwords, 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 and probably the most critical password is the password, and that's yellow because it's my daughter, a hand-me-down from my daughter. But the password to your phone. Why? Because most of us have dual authentication. And so you try to log in back to that brokerage account, you try to log into that brokerage account, and it sends a text to your phone. And if you don't have the password in the phone, you're stuck between a rock and a hard place. So that's kind of the documents. And again, feel free to, ask any questions, jump in, add anything to it. But that's the way I view the documents in terms of what documents do you aggregate. And here I really am talking about, not figuratively, but literally, kind of a binder or a folder that has these documents in them. Okay, so where do you keep them? It's kind of the next step. That's pretty simple. Oftentimes folks will keep their wills in a safe deposit box. Oftentimes they'll keep their wills and other estate planning documents at their attorney's law firm in their will vault. That's okay. to. I'm not a huge proponent of either one of those. I think the better storage location for those documents is a home safe or fireproof container. Safe deposit boxes are going away, but more importantly, and I have seen this happen, unfortunately, a couple of times, ultimately you can get around it, but the idea of what we're trying to accomplish here today is to make the process as seamless as possible for your loved ones. But if you have a safe deposit box and you're not on the safe deposit box, getting access to it can be extremely difficult. So I really don't like keeping originals in safety deposit boxes. I again think the better approach is a home safe, fireproof container, something like that. Who to tell? So and what to share, I would lump in this. Let's go back and kind of take this topic and break it down a little bit piecemeal. And let's start with your wills. So your wills are most likely going to have 3 fiduciaries named for y'all. For your aging parents, it's probably 2. What do I mean by fiduciaries? I mean, those are the individuals or entities that you've named under your will to take care of items when you pass away. So the first is the executor under your will, sometimes called a personal representative here in Tennessee, but it's the executor, the one that is charged with probating the will and administering your estate, which we'll touch on in a few minutes. So that's the first fiduciary, the executor. The second one is the trustee of any trusts that may be created under your wills. And then the third fiduciary for this group who have minor children would be the guardian or guardians. Who do you name under your will to raise your kids in the unfortunate event, heaven forbid, that both spouses pass away? So those are, for the will, the 3 fiduciaries. I think it's important to at least tell those individuals that they're named in the will. Usually the executor for probably this audience would be the surviving spouse. So really we're talking about the alternate executor if both the spouse and the client pass away. So I would, at a minimum, tell that individual. Some of my clients like to ask them on the front end if they're willing to serve, but they should have notice that they're named in the document. Whether you want to share the will with them, I'm agnostic about that. I think oftentimes the will is revised before it actually comes into effect. So while I'm agnostic, I'm not a huge proponent of sharing the will, but that is personal preference. So that's the executor. Same analysis with the trustee. If you have a will that creates a trust for the benefit of your children, then the person that you're asking to take care of that trust really should know that they're named in the document. And again, question about whether to share a copy of it with them. You can, but at a minimum, let them know that this document exists, that they're named in it. And then in terms of the guardian, same analysis. Now, in terms of who should know where these documents are actually located, think in terms of those fiduciaries. They should know, probably for our elderly parents and helping them, adult children, whether they're named or not, should know where the documents are at. So that's for the will, who to tell. I certainly wouldn't share a personal financial statement or any other ancillary documents that we talked about with anyone. I just let them know where everything is at and let those folks know that they're named in the estate planning documents. Healthcare power of attorney. So that I would share with the person that you name as attorney in fact to make healthcare decisions for you. I would let them have a copy of that document. I would share that document with your internist, your regular treating physician, at your next annual checkup, that kind of thing. So they have it on file. I think it's critical there. For our elderly parents, I think it's important, although sometimes they don't want to do this, it's important to share it with all of the children, even if it's just one child who is perhaps named as the attorney in fact, and the other children aren't named. And that's fine, but I think it is helpful for family dynamics that all the kids have a copy of that, all the adult kids. Durable general power of attorney, which again, based on the last session, you all probably know is a business, personal, financial power of attorney. So who are you sharing that with? I would limit that to the attorney in fact, the person that you name to step into that role if you become incapacitated. Again, that oftentimes is the spouse as the primary. So really I'm talking about the backup here. Who do you name as the alternate if the spouse isn't able to serve? And so that's who I would share the documents with, or tell them at least that they exist and where they can be found. Heaven forbid they need to look for them. So with that, I think the next topic is what I call asset alignment. And this is probably no subcategories, but this is in my practice what I have found to be the most critical step that can be overlooked post getting the document signed. And what do I mean by asset alignment? What I mean by that is making sure that how your assets are titled align with what your estate planning documents say. So I'll give just a couple of examples of that, and then we'll move on to the next topic. And this is really easy to overlook. So let me give a very typical structure for probably the large majority of this group. Go back to your wills or revocable trust probably say, if I'm the first to pass away, I leave everything to my surviving spouse, or it's left in a marital trust for the spouse. But if I'm the surviving spouse, or if my spouse and I die simultaneously, then my entire estate flows into a trust for the benefit of my children. And the terms of that trust can vary, but usually looks like, 25, 30, 35 are the ages that they can withdraw the trust. But the critical piece is that you spent the time and effort and paid fine estate planning attorney to create this trust. And the critical piece is making sure that it's actually funded if you pass away. So one kind of granular example to think about in the broader context is retirement accounts. So a lot of times those retirement accounts have a designated beneficiary, of the surviving spouse, which is great. I would probably leave it like that. But then the contingent beneficiaries are oftentimes your children, or oftentimes your estate. But a contingent beneficiary that doesn't align with having that retirement account flow into the trust for the benefit of your kids. So if the contingent beneficiary is your children, then it passes to them outside of your will and it doesn't flow into the trust that you've created for their benefit. So that's one example of asset alignment. And
Rick,
yes.
if I may, we got a question from our man Klaus. What are the pros and cons for creating a trust?
Well, a couple of things here. The type of trust I'm talking about is a testamentary trust for the benefit of your children when you die. That type of trust usually makes a lot of sense. The pros typically are anything that flows into that trust is has asset protection baked in. So your children's creditors, and under the kind of umbrella of creditors, I would include spouses in the event of divorce, and cannot access those trust assets to satisfy any claims they have. So there's this asset protection vehicle to it. It also is, a lot of times young adults, no matter how mature they are, maybe don't have the financial acumen to receive a large windfall inheritance outright. So placing it in trust is a means by which to kind of ensure that those assets remain available for your children for an extended period of time. And certainly, if you have minor children, you absolutely don't want assets passing directly to minor children. You want it to flow into a trust. And if it passes directly to a minor children, you end up with a court supervised guardianship over the property. And that ends up really being an unfortunate, timely, and costly situation. So that's the type of trust that I was talking about. There are other types of trust, revocable trust, that you create during your lifetime that's intended to avoid probate, which I can touch on, but not sure if that is responsive to the question.
No, that's perfect. And there's a question here from Georgia Uribe about probate, which is kind of timely. It says, so doesn't probate hold up safety deposit boxes? So if you put documents in there, your loved ones can't get to it until probate is over, right?
Not necessarily, but there is certainly the potential of a delay in accessing that box. And this is really a good segue into kind of this third topic of post-death steps and the probate process. And so I will circle back in just a moment to specifically address that question in the context of the probate process. But let me just take a step back for just a moment and talk about, high level, what do we really mean by the probate process? So the probate process is the means by which to validate your will and to validate that the person that you name as executor has the legal authority to administer your estate. All right, so what does that mean? Well, under Tennessee statute and every other state in the country, a will isn't valid until it's been probated, until a judge says, yes, this will was properly executed, properly witnessed, and the creator of the will had capacity to execute the will. So it is Rick Nichols, valid last will and testament. And yes, person named in the will as executor, you have the legal authority to administer the estate. Okay, so they are now granted what are called letters testamentary. Those letters, circling back to the safety deposit box question, those letters they are the magic ticket by which you can access everything that the decedent owned during lifetime that passes under probate. So an executor can access a safety deposit box once an estate is opened up. There actually is a statute that says if you think you're named as executor and you think the original will is in a safety deposit box at a bank, you can get access to it to see whether there's a will in there and if you're named. But it's a difficult process, and it is a wonderful example of what can be a disruptive process if the planning isn't done on the front end, right? So a question I get asked often is, on a regular basis, is, well, what are probate assets versus non-probate assets? How do I know if I have to probate a will or not? Probate assets are assets that are titled solely in the name of the decedent, so solely in your aging father's name, and it doesn't have a designated beneficiary attached to it, like a payable on death account, or it's not a retirement account with a qualified beneficiary named. Those assets pass automatically. It is the type of asset, a brokerage account that is solely in your father's name, and there's no payable on death and designation associated with it. That's a probate asset. A house that is titled solely in your individual name, that's a probate asset. So those are assets that have to go through this court supervised administration in order to flow on down to, under your will, to the beneficiaries. And so that's kind of the probate process. Having the will, having the judge say, yep, this is a valid will. Yep, you're named as executor. Now go administer the estate, marshal the assets, pay any debts, and distribute what's left to the beneficiaries listed under the will, and then come on back and close out the probate estate. That process lasts at a minimum from 4 months, because there's from the date that the estate is opened up, and there's a 4-month claims period, so the estate has to stay open during that period, and to anywhere from, typically 2 years. I have one that has been open for close to 10 years. So kind of within the bell curve, it's probably 6 months to 14 months, but there are outliers for sure. That's kind of the probate process. For the sake of time, let me just touch on some tax considerations, very high level, to be thinking about. Again, let's put this in the context of an elderly parent as opposed to any one of us. So there are income tax considerations for a decedent, as many of you probably know, having probably gone through this or perhaps gone through this in some form or fashion already. Income tax considerations, and then there are estate tax considerations. For income tax purposes, the estate is a separate taxpayer for which a separate reporting is required. So you would have a final 1040 for your parent to file. for the deceased, their final 1040 income tax return, and then any income that is generated by the estate while it's open would be reported on a 1041, and usually it flows through to the beneficiaries. But just know that the estate is considered a separate taxpayer for which a separate tax ID number is typically required. And so you have that income tax to be thinking about. And then for estate tax purposes, there's really a critical date here to be thinking about, and that is 9 months post death. An estate tax return, if it's required, is due 9 months following the date of death. And y'all probably are familiar with this and perhaps touched on it in the first series, but the exemption amount, which is the amount that you can pass to your family members before any estate tax is due, is 13,610 this year. It's going up next year to just shy of 14 million. A year from now, unless the law changes, and Jan 1, 2026, it's cut in half. So basically down to 7 million. And so if you have a taxable estate, you have to file that estate tax within 9 months of date of death. But if you don't have a taxable estate, there's still good reason to file that return if the surviving spouse is alive, and that is in order to port or use the first spouse's unused exemption amount so that the surviving spouse can tack that on to his or hers as well, so that they have taken their own exemption amount. And I'm going to go with 7 million, assuming in a year and a half or less than a year and a half, it's cut in half. So 7 million plus whatever the surviving spouse didn't use. So maybe that's 3 million. So you have a 10 million exemption amount as opposed to 7 million. But the way by which to do that is filing your estate tax return for the first spouse to die within 9 months of their date of death.
Rick,
yeah.
I'm gonna pull the plane up just a little bit. It sounds like getting all of the documents together
Yep.
is I would say maybe 80% of the battle.
Yeah.
And the 20%, I would say, based on what you're describing, is a function of understanding how they all work and what
Yes.
happens. In other words, I've got this. The documents are a set of plumbing. There's and then what happens when you pour water through it, and so what would you suggest that we, as either children of aging parents or doing our own estate planning, once we assemble those documents, make sure that what happens, the full consequences, unintended or intended, happen? How do we ensure that we're not dumping a huge tax burden on our children or our spouse?
Great. Yep. So with the aging parents, I think it is an audit, for lack of a better term, an audit of what documents are in place, what assets they have, how they're titled, and kind of understanding how everything is supposed to flow, and making sure that you have a firm grasp of what they own and how that's titled, and then seeing if it aligns with your parents' wishes. The good news, and really the same thing for y'all, I think would hold true. The good news is that if you do that exercise, all of this can be fixed, right? I mean, as long as you're alive, unless with aging parents, Alzheimer's has kicked into the point to where they lack capacity or something like that, and you really can't do anything to fix it. But in general, all of this can be redone at any time as long as you're alive. So that's the good news. So David, I think it is right. The heavy lift is getting your arms around the documents, understanding what assets there are and how it's titled, and seeing whether those mesh together.
Okay, so who would we contact from a title perspective? I mean, do I need a competent estate planning attorney to help me draft the documents? Do I need somebody else, maybe a trust administrator to help me understand what the flow of funds would happen or the tax implications, or who do I contact?
Yeah, I think for the documents, it is, probably the estate planning lawyer and preferably whoever drafted them. And they should be able to kind of, if they haven't already, explain it and maybe put together just a flow chart. Here's what the documents say as to how everything flows on first death and then second death. And then in terms of assets, if it's real estate, an attorney can help in terms of transferring real estate if it needs to be transferred. Anything else, then it really is kind of dealing with your financial advisor to have them help you kind of work through whether any assets need to be retitled.
Sure. A couple things to share with you all. My father passed away in 2018, and he was not only an amazing person, but he also it was also one of the most organized human beings on the planet. And he bought this book. It's called The Essential Planner. If I can get this not to fog up. There it is, The Essential Organizer. And it has pages upon pages upon pages of where everything is, all his assets, all the passwords. He was meticulous in this process. And I can tell you, without that, it would have been the dealing with the aftermath of his passing would have been a nightmare. However, there were still gaps. We still struggled to find some things within this within the whole process of his passing. Second thing is the implications of setting up trust and how that flows. I happen to be married to a certified trust financial advisor, which is helpful. However, you also uncover a lot of things. For instance, our house is in a trust, and the trust is in my name, and our mortgage is in both our names. So if I pass away, the house immediately gets transferred to our children, who are all wonderful people, and they would treat their mother, very well. However, my Renee would be on hook for the mortgage and not own the house. That's a problem. So it's to my point earlier, what I asked Rick about is making sure you have the documents in place. That's great, but do the consequences of those documents and the things outlined in them achieve what you want to achieve? We have a question here. Is there a benefit to getting assets into a trust before the estate tax exemption drops in 2026? Or can it still be fixed, as you say, later down the line, as long as you were still alive?
I think the critical piece there is simply think of that exemption amount, and I'm going to use 14 million for easy example, as two buckets. One is the basic exemption amount. The second is your bonus exemption amount, 7 million each. And for there to be any benefit before the exemption is cut in half, you have to use up your basic 7 million first. So you're talking about making an irrevocable transfer of at least $7 million before you can even tap into the bonus $7 million that is going to go away. So the benefit pre kind of 2026 planning is really for high net worth individuals who can transfer at least $7 million to an irrevocable trust outside of their estate for tax purposes, and then tap into that $7 million bonus, because that's what's going away. So it's use it now or lose it. But in order to use it, you've got to first use the first $7 million. And so So that's the benefit of any type of estate planning. Now, after the fact, there's always things that you can do. I mean, that's the wonderful thing about estate planning. There are always things that you can do. If you know, maybe you didn't plan ahead of time, and there are always options.
Awesome. I'm going to drop in a link here into the chat. This is a document from our good friend Greg Lucan, also NEO member. This is a fantastic document of what to do in the event of the passing of a loved one, and like what to do in the first 24 hours, the first week, the first couple of months, the first year. I shared this with Rick, and he was duly impressed. And so we got a seal of approval from a competent attorney here. But I would challenge anybody reading this document to then turn it on themselves. Okay, what is, if I were to pass, would all the things that my loved ones and anyone else who I left behind have to deal with, and is that in order from that perspective? So I would encourage all of you to download this document, and if you have any problems, let me know. But it's a tremendous process it's print this document to help you through the process. Are there any other questions? Open up the floor here. You need approval. Yeah. Okay. Yeah. All right. Hang on. I'll fix that. I'll fix that. Question.
And David, I can always just save it as a PDF and send it out when I send the recording link and all that stuff.
Yes. Thank you.
Perfect. And do you want to also, do y'all want to share your screen for the document Danielle put together as well, or how did y'all want to handle that?
We have another document Danielle put together, basically aggregating a whole bunch of materials, or checklist, if you will, of things to consider on passing. We can set that. We can share that as well. Any other questions? Thoughts? Threats?
I have a question.
Concerns? Please.
Yes. So I know in Tennessee we have the Tennessee Investment Trust, right? Option, which is great if you have businesses. Do you, when it comes to taxation of it, I know trust taxation is quite heavier, but that just flows through your personal tax return, right? Since you are the what is it called? I'm trying to blink. The grantor and the yeah.
Right. Yeah. So the acronym TIST is for Tennessee Investment Services Trust, and that trust is Tennessee's version of a self-settled asset protection trust. And you are treated for income tax purposes as the grantor, and so it's a grantor trust and basically disregarded for income tax purposes. And so all of its income deductions flow through to you, and you just pick it up on your 1040. Yeah.
Is that valid also for the inheritance trust that triggers from a parent passing? When I'm the trustee of that trust, you know, the grantor obviously was a parent, and then
right. That's different. That is a testamentary trust, right? That the parent created, and you're the trustee or whomever, but they created that trust for their family members. So that trust is a separate taxpayer and not treated as a grantor trust. So the trust itself is a separate taxpayer, and any income that it has to be reported on a 1041. And you usually, on that 1041, you usually have a K1 that goes out to the beneficiaries that kind of flows out the income that the trust is generating, and the beneficiaries typically, not always, but typically pick it up on their own income tax return. So different types of trust there for in terms of how IRS views them.
But okay, but neither of them will get trust taxes because it does flow through the either in one case the grantor, the other case the beneficiary.
Yeah, if there's right. So a simple example of when that trust would have to pay taxes is that testamentary trust that we're talking about. If it's got a couple $1 million in it and it generates $100,000 of income, but it doesn't distribute that out to the beneficiaries, it just
Ah.
holds it, then the trust is going to have to pay the tax on that trust income.
What if there's an investment under that trust name? What if you buy real estate and you keep it for 20 years?
Yeah, so same analysis for tax purposes as if it were held by an individual or any other type of entity, an LLC. And if you're holding real estate and it's not generating income, there's no income to report, but upon the sale of that real estate, you're going to have capital gains. And again, if the capital gains are distributed out to the beneficiaries, typically can push that gain out to them at their individual income tax level, or the trust is going to pay it. But at some level, whether it's the beneficiaries or the trust, that capital gains tax when you sell the real estate 20 years or whenever it is going to be paid.
Well, then I guess what I'm confused on, not on the tax part, but say that
Okay.
the testamentary trust,
Yep.
you know, you have this testamentary trust. Now you have acquired some real estate. Now I want to do investment with the real estate and I have investment. Eventually that money has to be paid out to the beneficiary, but the benefit of the trust is it is creditor protected trust, right? This is a testamentary. The moment I take that money out of the trust and pay it to the beneficiary on the individual level, say that's also me, I'm exposing that money to creditor, right?
Yep.
The good
Correct.
thing about the TIST is that it stays in the TIST and you can keep it in the TIST, right? Like I invest, but then there's also a bank account. You can keep cash. You can make a CD. You can do anything an individual does that in a TIST, but money stays in a TIST, stays protected, stays sheltered.
Right.
But the other trust, the whole point of inheritance money is to protect it, and it's not, you know, it's yours, but it's passed through the parents. And how can we keep that protected then if we have to distribute that money out of the trust?
Well, okay. So high level, the test is something that you're creating yourself, right?
Yeah.
And so you're setting the terms for it. The testamentary trust is something that your parents have created. And the simple answer to your question is that testamentary trust could have said it stays in trust. It could have been what's called a dynasty trust. It stays in trust for the lifetime of my kids. It stays in trust for the lifetime of my grandkids. It can stay in trust for 360 years under Tennessee law. The downside to that, as a practical matter, is that most parents, most of my clients, want to protect their kids, but they don't want to necessarily rule from the grave by tying up assets for a child's entire lifetime. So there's kind of a pro and con to that discussion of you're exactly right. And as long as it's in that trust, asset protection applies. But there are cons to keep it in trust where you don't have unfettered control over the assets. So it's a balancing act.
Got you.
At the risk of oversimplifying, this stuff is complicated, and you can do your absolute very best to make sure that you got your ducks in a row, you have your documents set up, you've got them in a fireproof safe, and everything's fine. But you know, as you just pointed out, it gets complicated quickly, and there's lots of tax implications, and they change, you know, year to year. So Danielle very graciously dropped in Rick's contact information there in the chat. We're getting up on, we got 6 minutes left, and we're gonna finish this on time. Does anybody have any other thoughts or questions? I'm gonna put Elizabeth Moss on the spot because she kicks ass in this space and she knows all about dealing with aging parents, and she's amazing. I highly recommend reaching out to Elizabeth if you get stuck on how to have these conversations with your parents. She's a pro.
That is a great promo point for our next series or for our last series, because Elizabeth and Chris Gay are gonna be joining forces to talk about some of those exact topics. So I do want to, can I quickly share this document on screen that we put together?
Yeah.
Okay.
And the one with Elizabeth will be December 6th, so be sure and sign up for that.
Yeah, the conversations are tough. They're tough to have, even if you're talking about somebody else. And they're tough to have when you're talking about yourself. So Elizabeth's great at helping understand and
They
navigate
are
that.
tougher when it's your own family. Take it from one who's been doing this for 30 years. And then when it came to my family, you know, I would get pushback from my mom who lived in Arizona, who would tell me it's different here. And I could not get through to her that Medicare and Medicaid, there are some nuances in those states, but overall things are not different.
So this document, which I will send as a Word and an editable PDF, is long. I will preface that it is 27 pages of really great tables to store all of your information in. You can see through this table of contents what we've all covered. It is meant to be lengthy because it is meant to try to encompass everything you could think of when it comes to gathering information for either yourself or your loved ones when you're planning. I will say, if you're going through this and maybe you think of something that's not on here, I would love to know about that so we can add it in and, you know, continue to provide this as a resource. You know, I don't think it's in our interest of time a good idea to go through all of it, but this is sort of giving you the layout of what it looks like, and you know, is just really comprehensive of contacts and information on, you know, how do you want your kids to be cared for? What are their medications if both spouses were to pass away? Like, you know, what doctors do they need to see? And, you know, what's your password to your phone? Like Rick was saying earlier, for multi-factor author MFA. That's all I know. And so we'll send this out to you, as well as with Greg's great document that he provided us.
Well, if there's not any more questions, we will wrap this up. I want to thank Rick Nichols from Bradley for joining us and helping us through this. This is heavy stuff. This is not, you know, easy to contemplate. Rick, you make it look easy. I
Well,
think the biggest takeaway is talk to a lawyer and start the process and get this underway. With that, I'm going to turn it back over to Danielle and Samira and for promos of our next one with the lovely and talented Elizabeth Moss.
So-
Actually, the next one is November 22nd, and that is going to be with Abby and Kyle with Continuum Planning Partners and Viking Mergers and Acquisitions. So that will be huge in terms of like identifying and grooming your potential successors, understanding the legal and financial implications of various exit strategies, on and on. And then we will have the one with Elizabeth and Chris Gay, which is kind of the lighter topic of, okay, what if you do live longer and, you know, nothing tragic happens? Do you understand what you're kind of getting yourself into? Some of us are kind of in the middle of that. Some of us are blissfully unaware. Highly recommend that you tune into both of those, and just really appreciate your feedback. I put the link in the chat. If you just take, I mean, I promise you it doesn't take more than 30 seconds at most. Just give us some feedback so we'll make sure we are giving the people what they want.
So what you're saying is blissful ignorance will only get you so far.
Ding.
Correct.
Got it. All right, y'all write that down.
Rick,
about
thank you for being here. You know, your information is so valuable, so we appreciate your time.
Oh, happy to do it. Thank you so much for having me.
Y'all
Awesome.
have a great weekend. Thank you so much.
Bye,
Thanks,
everyone.
everybody.
Bye-bye.
Thank you.
Thank you.